is concerned that the sequestration order has been violated. He has changed
Yes.
a very key aspect of this matter
Yes.
after
Yes.
the testimony of Mr. Griffin, after Mr. Griffin presenting a timeline.
I think Brennan is gaslighting us again. Let me know in the comments below if you think Brennan is gaslighting us again. Sorry, I am very angry right now. I don't know if you are. I am very, very angry.
The seconds are important. Literally 1 second can turn not only Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it.
My findings for the record are that the defendant has not persuaded me of undue surprise or unfair.
We have a judge that is in cahoots with the prosecution, so she's just doing unlawful things, followed by more unlawful things. And anytime Brennan says jump, the judge is like, we're jumping. Well, hello everybody, and welcome back to Buckle Up, It's the Law. Folks, today we are going to be doing something that you all have been waiting for and asking for the last couple of days. I've been reading your comments, I've been reading Twitter, I've been reading your comments on my videos, and let me tell you, I know this has to be covered. This is one of those bizarre situations where Auntie Bev is making a ruling on something that I think shouldn't even be an argument. I'll explain why as you watch the video. But basically, anytime the defense does something that the prosecution doesn't like, oh, everybody's up in arms about it. But the minute the prosecution does something wrong, it's like, oh, well, you know, whatever. You'll see what I mean. Let's watch, because this is horrific.
All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. Yesterday, Your Honor discussed with the parties, and parties were heard with regard to the issues we have raised with regard to the timing of the May 8th report from Mr. Burgess that the defense received on May 11th. And what I wanted to do, Your Honor, is briefly provide the information Your Honor asked for yesterday, which was how much time we might need under various circumstances. And so I wanted to take a few moments to put that in context. It will only take me a brief amount of time to do so. So, Your Honor, there is a timing issue, but there's most importantly a substantive issue. I will not, of course, go into the detail of yesterday, but the timing really is informed by the substantive issue. And so, with regard...
By the way, let me just say for the record, I love that Alessi is doing this all from memory. That right there shows a lawyer who's prepared, who read the information, understood the information. He doesn't need notes in front of him. It's all in here, and it's ready to be compiled in a nice, neat little package to the judge. So let's see what happens.
To the matter, we went back and we looked at more deeply the effect of this timing and this movement of the what has been referred to as clock drift in Mr. Burgess's report that we got on May 11th. I spoke of the significance yesterday, and here's what I would like to add as is relevant to the time we're going to need. I again urge the court to reject it substantively, because what we did was we went and we looked at matters such as the cross-examination of a key witness in this case, Jennifer McCabe. She testified with regard to observing a vehicle at 12:45 a.m. And that's a significant point. I know I don't need to elucidate for Your Honor.
And just real quick, two things. Number one, this argument was made on Friday, May 16th, so just a couple of days ago. And number two, and most importantly, this is a report that has been given to the defense, as Alessi has just said, very recently, less than a week ago, business-wise, you know, at the time that he was arguing it, the same week that he's arguing it. That is, as you will see, contradicts And it completely unravels some of the stuff that the prosecution has been claiming, not just in the first trial, but already in the second trial. It's unbelievable. And the witness is just changing tune like nothing. You can't do that. And the court shouldn't accept it. That's why Alessi is urging the court to completely exclude the report.
All of this is going in significant part, if not total part, to what has been as alleged a collision here, which we vigorously contest. It just no collision ever occurred. But the timing of it, the timing of what's alleged by the Commonwealth is very important. The seconds are important. Literally 1 second can turn not only the Commonwealth's theory completely around in circles and debunk it, but also the jury's analysis of it. And this is the point I wanted to elucidate today, is that the jurors have been provided information, and the defense has aimed its defense on this claim based upon, in large part, timing. So now what we have is on May 11th, Mr. Burgess changing the timing. So what does it affect? Not only witnesses like Jennifer McCabe, who we strategized with regard to, but also my decision to not even cross Trooper Guarino, because Trooper Guarino had testimony with regard to when Ms. Reed connected with the Wi-Fi at One Meadows, and there's a certain time associated with that. We have Mr. Griffin, who went through, the Commonwealth went through a timeline, and we believe they went through a timeline for the theory that they had, and we
covered both of those witnesses on the channel, so if you don't know what he's talking about, go check it out.
I cross-examined Mr. Griffin extensively with regard to that timeline. There were several defense strategies and effectuations of strategies based upon that timing. So with regard to the substance, Your Honor, and there's more, but I think that's a fair representation. It innervates our entire defense. The question now of Your Honor of how much time it will take the defense to react to Mr. Burgess, I wanted to say it's not only a reaction, but it's a substantive defense analysis, and 3/4 of the effectuation of that has already occurred through our presentation in terms of cross-examination. So we would have to, and we're still evaluating that, revisit all of that. And secondly, we would have to put that into the calculation of all of our witnesses that we've already prepared,
right,
that are based upon that timeline.
The Commonwealth cannot literally change the entire substance of their prosecution in the middle of trial. Not just middle of trial, the middle of the second trial, the retrial. That's Alessi's TLDR point, and I completely agree with him.
It is a very significant point, and to the extent that the Commonwealth tries to argue, well, you know, we never really committed that much to a certain time period. I again urge the court to look at the report of Dr. Judson Welcher, where he has 1162-2 with a specific range, 1238 to 43. And even in their range, it's a very small time, which further supports how each second matters in this regard. Now to the answer to the question Your Honor asked yesterday. Again, I urge that it just be rejected and we keep this trial moving in its current pace. To the extent that that does not occur, and again, we urge that it be rejected, the report, because it's a Rule 14 violation, there is no remedy for the defense. However, to the extent, and given Your Honor nonetheless asked me for an answer in time, we would need 4 days to be able to address it. We will not ever be able to recover strategically or substantively from it, given all that's been presented to the jury, and it will be very difficult to figure out how we're going to go.
They're not going to be able to recover strategically? Do you understand what that means? Do you understand what he just said? He basically said the Commonwealth is ambushing us with a BS report that changes the entire case. It unravels it from the ground up. Everything we have been building up until now is now going to be literally just imagine a piece of paper being set on fire and it just unravels and turns to ash. That's what he's saying is going to happen to the defense's case if this report is admitted and if this witness is allowed to testify about this report. That's insanity. That is huge. And it cannot happen and it should not happen.
Present a defense after we've already presented to the jury our defense in our cross-examination. It's not really structurally possible to simply take 4 days and address Mr. Burgess, because we can't go back to all the witnesses I just mentioned and others and start crossing them and eliciting testimony with this new time period in mind. But I wanted to answer the question, Your Honor, respectfully. It would be 4 days for us to even go from where we are now and then try to alter not only witnesses such as Arca, but DeSogra and Gaffney and other types of witnesses that we have in that regard. So, Your Honor, respectfully, that is my response.
All right. Does the Commonwealth want to be heard?
Yeah.
Okay.
All right, Brennan, what do you got, buddy boy?
Respectfully, Your Honor, the defense is very confused. They attempt to confuse the issue. They attempt to confuse Your Honor about what the impact will be. This has never been a change. The government is not changing their timeline. The Commonwealth is not changing any information. The Commonwealth is not offering anything that affects in any way the testimony of witnesses. It's notable in the argument there is no relationship to the facts of the actual report that was provided. The Commonwealth has always provided the data, which they have, and they hadn't a chance to analyze. And the interpretation of the data has been different between the parties. We have been clear from the beginning at the time in which the infotainment system shows that there was a collision. We've been clear. And the data has been clear. That has never changed. That data in the telestream system is based on a clock in the Lexus, which both sides know full well is different than a clock in an iPhone. You can see all the productions of Dr. Welcher's PowerPoint presentation where it shows that time, 12:31:43, has never changed. Also, it has been clear that both sides appreciate that there is a variance between the clock in the Lexus, which leads to that system information, and a clock in an iPhone. In fact, the defense was so aware of it, they hired an expert, Mr. DeSorga, who gave his opinions about that variance. We have never suggested there was not a variance in this case. In fact, we have highlighted the variance. When their expert, Mr. DeSorga, provided a report, we believed that his analysis was wrong. And so we looked at the variance and the data that was available from the telestream system and John O'Keefe's Waze data that was on his phone that was always available to all of the experts in both sides. And when Mr. Burgess looked at the variance at the time of a three-point turn about 7 minutes before the collision, he simply matched the Waze information on Mr. O'Keefe's phone to that of the information from the telestream and saw that it was a 21 to 29 second variance. All that data was available to the defense because their expert made an improper conclusion is not our fault. This does not change the testimony of anybody. They point to Jen McCabe.
Wait, what improper conclusion is Brennan talking about? A conclusion based on the data that you have now changed? So this conclusion is going to be different? Isn't that what you expect to happen? Am I missing something? Because that doesn't feel like I am. I think Brennan is gaslighting us again. Let me know in the comments below if you think Brennan is gaslighting us again. And like this video, and don't forget to subscribe to the channel if you haven't subscribed yet. Sorry, I am very angry right now. I don't know if you are. I am very, very angry.
Text message where she said she thought she saw a motor vehicle out front that evening at 12:45. That is not consistent with the Commonwealth's timeline, but that doesn't change. That favors the defense. It does not change anything to do with ARCA. ARCA has not, as far as I've seen in any reports, ever talked about the variance, just Mr. DeSorda. And so because this is inconvenient for the defense,
Inconvenient?
and because it further focuses the variance that we've already discussed and provided, isn't a reason to exclude it. It's not late discovery. It's not a Rule 14 violation. It is further analysis of information that was already provided, opinions that were already provided, and it is in response to their experts' mistake about that variance. There's nothing new here. Nothing has changed.
Reply?
Go right ahead, Mr. Alessi. The only question I had for you yesterday, for you to respond to today, was the time, so I gave you more leeway.
And
So
you're giving me more leeway, and I appreciate it.
go right ahead.
So, 2 items, Your Honor. As I alluded to yesterday, and it's been a point that Mr. Brennan just made, we believe strongly, Your Honor, that at a minimum there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a
Okay,
series-
if nothing else, he knows he's probably going to lose this, and we're about to find out in 7 minutes whether or not he wins or loses his motion to exclude Burgess's new report. He's basically saying, look, Your Honor, if nothing else, if you're not going to exclude the report, which I anticipate you won't, give us a chance to voir dire him. What does that mean? Outside the presence of the jury, ask him questions. Remember what you did to Arca? When they made Brennan look like a fool, and he's like, okay, I need to change gears here. I need to manipulate the evidence in a way that makes it look like things that didn't happen happened and things that happened didn't happen. I think this whole timeline change is in direct response to his failure, Brennan's failure before Wolf and Arca. Now he's like, well, if I can't change the witness, if I can't exclude the witness, I need to change the facts. Hey, expert, change the facts for me. And that's what they're doing. That's why I'm so angry, because they are changing the facts in the middle of a trial. That is why it's unraveling the entirety of the defense's theory of the case, because the facts are being changed. So Alessi's saying, look, if you're not going to exclude a fact change, what I'm asking you to do at the very least is let us question this schmuck, put him on the stand, outside the presence of the jury, and let me rip into him just to make sure that I am prepared for when it's actually in front of the jury. I'm not totally blindsided. I need 2 bites at the apple. Let's see what Bev is going to do after he's done.
Is concerned that the sequestration order has been violated. He has changed
Yes.
a very key aspect of this matter.
Yes.
After
Yes.
the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline in his report, Mr. Burgess, his new purported report of May 8th, he references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report, is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire.
Oh, that's a really good point. Because if there is a violation of the sequestration order, if he, Burgess, listened to Whiffen's testimony and that allowed him to change his report to fit better with the Commonwealth's theory, well, then he can't testify, period. He violated the sequestration order. That's the end of the analysis. You don't even need to go any further. Sir, have you been listening to witness testimony? Yes, I have. Thank you very much. No further questions. Sir, you may be excused. You cannot testify in front of this jury. That's it. But, of course, he's never going to admit to it, even though we all know he did it. At the very least, Alessi needs a chance to strike at him before he gets to testify in front of the jury so that they can prepare as best they can for the BS that he's about to spew to the jury. This is insanity.
Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. Lastly, Your Honor, with regard to Mr. Brennan's point, he made it yesterday and I corrected it, he said it again today. that supposedly our witness, Mr. DeSogra, made an error and that we're trying to correct an error of Mr. DeSogra. That is incorrect, Your Honor. Again, Mr. DeSogra was responding to Mr. Burgess's report. Mr. DeSogra's report is entirely saying, okay, Mr. Burgess says this, and therefore the defense says this. Now Mr. Burgess is changing what he is saying. So it is completely incorrect to say that Mr. DeSogra is trying to correct an error. That would require, again, Mr. DeSogra to change what he has done. Final point is this. There was also an issue, Your Honor, and this is extremely important with regard to burden shifting. There's not only the question of should this be allowed at all, there's not only the question of how much time the defense will need, but there's a third and important issue, and that's burden shifting. What Mr. Brennan proposed yesterday was a very irregular process where essentially the Commonwealth gets 3 bites at the apple for a problem that they caused. The problem we're talking about is Mr. Burgess changing a significant part of a timeline. Yes, there was a variance that he had, but he picked a range of the variance. He's now changing the variance. So what the Commonwealth is proposing is that our witnesses go forward, the aperture gets to wait, they come on, and then the aperture gets to come on yet again. We would urge
I did not understand the Commonwealth asking me that. Are you asking me to do that, Mr.
I
Brennan?
appreciate the
I'm
clarification.
not sure what he's saying, so.
It sounds like...
I'm not sure what he's saying. Brennan, are you listening, man? Are you in the room, man? Oh, I'm fuming.
Oja or whatever,
His name is DeSogra, yes.
DeSoder, you're suggesting that the Commonwealth suggested yesterday that he testifies first and then the aperture witnesses?
What I understood was going to happen is Mr. Brennan said yesterday that Dr. Welcher cannot come in until after.
No, I didn't understand that. I understood Dr. Welcher, Shannon Burgess, and then Dr. Welcher for everything that you folks received prior, January 31st or whatever the date was. And then potentially for all the new ARCA information that came in May 7th, that portion, Dr. Welcher returning on rebuttal for. Not that they were holding back Dr. Welcher completely. Is that correct, Mr. Brennan?
That's the conversation I had. That conversation I wasn't part of.
Yeah, I think you misunderstood that, Mr. Alessi.
So just so I'm clear, what is it that the rebuttal?
Mr. Brennan, all right, this is separate, and I'd really like to give everybody a break here. What is it the Commonwealth is asking to do regarding that?
Regarding Mr. Burgess or Mr. Welcher?
Which, Dr. Welcher.
Dr. Welcher should come in and testify to his PowerPoint, all of his opinions, which address all of the prior representations and opinions of ARCA, although we still don't have any raw information, but we're ready to move forward. Regarding any new opinions, which there is over a dozen new opinions that includes testing, video, experiments, Dr. Welcher should have enough time to review, conduct his own testing, turn it over, and then in rebuttal, address limited to the new issues raised by ARCA.
That's how I understood it, Mr. Alessi.
And that's how I did also, but the question is now with the Burgess changing of the clock drift, how many times is the Commonwealth proposing that Dr. Welcher gets to come in and talk about that? Is he just going to come in and talk about it?
So you talk with Mr. Brennan about that. All right.
Okay, and for the record, just so you understand, I know I made this comment earlier, but sometimes expert witnesses are permitted to listen to testimony. Sometimes they are not. It all depends on what it is. But if Brennan is actually feeding information to his expert witness in order to fill a gap, sometimes that sequestration order can be violated. You can't just listen to everything and just prepare your report. Like, if he was listening to Jennifer McCabe, that's it. That's a rule violation. If he was, Burgess was, I keep saying he, I think it's a she now. Shannon Burgess. I'm sorry, I forgot about it from the first trial. It's hard to keep up. There's like 150 witnesses, so in my defense, please excuse me. But at the end of the day, if Burgess is going to be providing testimony that has been changed as a result of her listening to non-expert witness testimony, she should be excluded, period, the end. She must be excluded, period, the end. But if she has been listening to limited testimony of just other experts, sometimes that is permissible. I don't know if this judge permits it. I think she has a global sequestration order, so even that may not be permissible. Although in most trials, you will have expert witnesses, and you will literally ask them as the first question, you know, who are you, what do you do for a living, and what's your background and education? The first question you will ask them, you'll be like, so, have you been listening to so-and-so's testimony? Yes, I have. And what do you think about that? They are completely wrong, and here's why. This is normal stuff. If Auntie Bev narrowed the scope of the sequestration order, or if the expert witness goes beyond the permissible sequestration violation that they can do, like listening to Jennifer McCabe and listening to Higgins and Buchanan and whatever, and the other timelines, Carrie Roberts and Jennifer McCabe, remember the timeline? Then she cannot testify. Period. She cannot testify. She's in violation of a court order. Not only is she in violation of a court order, she's in violation of listening to courtroom testimony and making a determination based on improper information that she should not be in possession of. And yes, it's available. Yes, anybody can watch it. Yes, anybody can click a button and watch a video. But if she's a witness in a trial, certain rules apply to her. My God. This trial is getting derailed.
So I'm all set for this.
There are no changes. There is no changes in the timeline. He keeps trying to portray this as something has changed. Nothing has changed. It's the exact same. He's always said there's a variance. He's been looking into the variance for a long time, and now he has found a method to show the exact variance. It's not changing. There's nothing in the reports that changes as far as the timeline. That's just an attempt to cause fear. There's nothing that has changed. We can look at the reports. It's all the same, always has been.
She's already made her decision, Brennan. Sit down.
The mistake of their expert, and that led him to be able to identify the
So why isn't she cutting him off? Why is she letting him ramble? She's already made a decision. If Alessi had been doing that, she would have been like, Alessi, sit down. We're done here. But because it's Brennan, she's like, yes, sir. Uh-huh. Okay. Let me sit down and listen to you. Like, her bias is so clear.
Which is helpful and new. And the suggestion that there's been some violation of an order, no good faith basis whatsoever.
Does the Commonwealth oppose a voir dire just on that one issue?
Yes, because it's suggesting that there's a good faith basis for it. Nothing has. Ian Whiffin's report.
Wait. Brennan doesn't even want to allow a voir dire of a witness? Like you did with Arca?
The defense and our experts months and months and months ago. The issue of variance has been an ongoing issue for months. There's nothing that triggers a change in the testimony to adopt or adapt to it. Our timeline has been the same since when we turned it over at the beginning. They cannot point to one thing that has changed between Dr. Welcher, Ian Whiffin, Jessica Hyde, or Shannon Burgess. They are just saying things without a good faith basis. In the reports, show us where something has changed.
Your Honor, to inform you, Your Honor, we would like to print the page in the clock adjustment because what Mr. Brennan says is
Yes,
correct.
and I'm happy to any information.
Thank you.
All right.
None.
Thank you.
All rise to the court, please.
Okay, now we're going to cut to the ruling.
So before we recess, I appreciate the council provided me with the information. Mr. Alessi, I got the 2 reports that you had that were incorporated in what the Commonwealth had given.
So what we missed and what was skipped, because obviously that's just staring at the OnlyFan. And by the way, don't forget to subscribe to the video. Subscribe to the channel. I can't talk. I'm so angry. I'm beside myself right now, folks. And I don't know what she's about to say. You might know because you've already seen it before. But I'm going to be reacting to this in real time, like I do with all of my videos, or 99% of my videos, I should say, because I like to be surprised. And like I said, I'm still catching up. I'm doing this one out of order because everyone's been asking for it, and I don't want to leave you guys hanging. So we will continue with like Brennan. I'm sorry, Brennan. See, my brain is just shutting off because this is, I'm so angry, but I'll be fine. I'll be fine. So We'll do like Buchanan and Higgins and all that other stuff next week. As I'm still a few days behind in with all the testimony, but that, like I said, that's okay. This is the beauty of this trial, is that as I'm playing catch up, you guys get more content, and I'm gonna continue with 3 videos a day at 1 p.m. Eastern, 4 p.m. Eastern, and 7 p.m. Eastern Daylight Time. All right, Bev, what do you got for us?
Me a few minutes before bed. I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination, certainly as to what Mr. Burgess knew, what he looked at, why he looked at it, when he looked at it, why he changed his report. In violation of the sequestration order is all for cross-examination. I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on that. Mr. Alessi, I can tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps, if you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well.
Wait. She did give one little nugget. She said, no, but Mr. Alessi and team. And this is very, 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 very important. Listen closely. After Ms. Burgess concludes her testimony, I am going to give you a chance to recall witnesses should you need to recall them. And there may be a few of them. There may be a numerous amount. And we're not talking 2 or 3. It may be 6 or 12 witnesses. Auntie Bev just said, I will give you a chance to recall them, and I will give you leeway during cross-examination to hammer this witness. So that's the second piece of the gift, if you want to call it that. I am still disgusted by what is happening here. The Commonwealth is doing everything in their power to try and win unethically, unlawfully, as you guys like to say, illegally. Is that even legal? My favorite question. This is 100% illegal, if you really want to look at it that way. But we have a judge that is in cahoots with the prosecution, so she's just doing unlawful things, followed by more unlawful things, and making the defense's life as miserable as she possibly can. And basically, anytime Brennan says jump, the judge is like, we're jumping. For instance, ARCA. She could have just said, no, we're not doing a voir dire of the ARCA. Yes, we're doing voir dire of the ARCA. Why? Because that's a defense witness. Brennan had nothing. Not only did he not have anything, the ARCA video of Brennan getting embarrassed by Dr. Wolf is one of my most watched videos from this trial. Do you know why? Because it's so dumb. Because Brennan looked like a fool. He tried and he tried and he tried to poke here, and he got angry and he started like false yelling, and there was the little signal to the judge where she put her glasses on. If you saw that short and the long form video, it's part of the ARCA video. So anytime he's like, Judge, we have a problem here, I want to voir dire a witness, she's like, sure, yeah, no problem. Which witness do you want to voir dire? But the minute the defense is like, I want to voir dire a witness, she's like, nah, no, you don't need it. Screw you. Sit down. Anyway, Mr. Brennan, your next witness. You are all set, Mr. Defense Team. Unbelievable. And by the way, if you need a lawyer, you knew this was coming, because I try to plug my firm in every video or every other video. 1-844-774-HURT. By the way, we're looking for a new lawyer. So if you know anybody who does personal injury, for the first time in our career, we're actually looking for a personal injury attorney to join our team. It has to be local. It can't be remote. So if you're in Wyoming or California or New York, I'm sorry. But we are looking for an attorney to join our team here very shortly. So spread the word. I already posted it everywhere I could. Figured might as well talk to you guys as well. And yeah, 1-844-774-HURT. We're getting so many good injury cases. We're going to be recovering millions and millions and millions and millions and millions of dollars for our clients. Tens of millions, hundreds of millions. Eventually we'll get to the billions, but we're not there quite yet. And it's all about helping you all. The little guy who got hurt in a car accident, or you know, if you were walking down the street in front of Costco or whatever and tripped and fell because the sidewalk was improperly paved, or a dog bite, you know, by a neighbor's dog. Anything where you got injured, it wasn't your fault. The only thing we don't do is workman's comp. So if you're injured on the job, I have a firm that I farm all of that work to here in Kentucky. So you can still, if it's in Kentucky, call me. But yeah, anyway, enough talking about me. Let's finish up this video.
So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan?
Hopefully next week, if not,
All right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies, the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
All rise for the court, please.
Wow. Wow. Just wow. Norfolk County Courthouse, the building where justice goes to die. Well, folks, I hope you enjoyed it. I hope you learned something. I wonder, let me know in the comments below if you're as angry as me and as you scroll past. Obviously, don't forget to subscribe if you haven't already. And I will see you all in the next video. Bye, everybody.